Sharma.
My lady, the next witness is Daniel Bruce.
Can you repeat after me, please? I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
I hope we haven't kept you waiting, Mr. Bruce.
Not at all.
Could we please start with your full name, please?
Daniel John Bruce.
Mr. Bruce, you have provided a witness statement to the inquiry adopting the evidence of a prior witness, Mr. Munro. My lady, you've previously given permission for witness statements to be published. The I&Q numbers for those are 527634, 574178. And for your witness statement, Mr. Bruce, would you please confirm it's true to the best of your knowledge and belief?
Yes.
Mr. Bruce, you are the Chief Executive of Transparency International UK, and you've held that position since October 2019.
That's correct.
Transparency International UK is part of the UK Anti-Corruption Coalition. Could I start, please, by asking you to tell us a little about the UK Anti-Corruption Coalition?
Yes, thank you. So the UK Anti-Corruption Coalition is an informal collaboration of civil society, organisations, academia and independent experts made up of around 16 full members and up to 30 when we include our affiliate members, broadly aligned around principles of transparency in public life, the prevention of corruption, the promotion of integrity, and effective enforcement of regimes around those areas. For the purposes of the inquiry and our work more broadly in this area, the coalition established a procurement working group, which is made up of the organisation that I lead, Transparency International UK, along with the Open Contracting Partnership, Spotlight on Corruption, the Centre for Health and Public Interest, and two independent experts, Russell Scott and Chris Smith.
And as part of your work with the UK ACC in relation to public procurement, you've conducted a number of investigations and published a number of reports, haven't you?
That's correct. So at Transparency International UK, we produced a forensic investigation into the UK government's first 1,000 COVID-19 contracts and our assessment of corruption risks therein. That was published in April 2021. Subsequently, we published a more extensive analysis of 5,000 contracts with a sample going out into 2023, a report entitled Behind the Masks, which we published in September of last year. Similarly, Spotlight on Corruption, using freedom of information requests and other means, has conducted various investigations, for example, into waste and loss associated with contracts that went through the high priority lane. And our colleagues at Open Contracting Partnership have produced a lot of analysis drawing upon data sources such as the European Union's Tenders Electronic Daily and the UK's Contracts Finder to analyse procurement patterns during the pandemic. And both Chris Smith and Russell Scott have extensively used the freedom of information regime to seek to ascertain information about individual contracts or batches of contracts or spending that at the point they submitted them was not in the public domain.
We're going to come on to some of that analysis during the course of your evidence, but could I first ask you some questions about the principles around public procurement? We've heard this morning from Professor Sanchez-Graels about issues with governance, accountability and transparency. Why should this inquiry be concerned with those principles during the course of an emergency such as the pandemic?
Well, as I hope our written submission shows and the evidence that we will discuss, there was a a significant collapse in the transparency regime around public contracting during the COVID-19 pandemic in the UK, and this stood out in the UK context relative to some of its peer countries, and I know we'll come on to that later. But I guess the fundamental question is transparency a nice to have in an emergency of this nature, or is it a necessity? And we would certainly align ourselves with the latter for a variety of reasons, perhaps foremost among which is that we would contend it leads to better procurement outcomes, and therefore it leads to a better response to the pandemic. More transparency around public spending ensures that buyers and suppliers are better connected, that there is transparency around how much things cost, and therefore government is able to spend its money faster and better with a better transparency regime. But the second consideration, which is equally important really, is that when a pandemic response like the UK's slips into a void of opacity around public spending and the associated mechanisms around it, there is a significant decline in public trust. And there are multiple points of data and evidence, both in our own work and that which is already in the public domain, which show how the perception of corruption of public money, the perception of waste or maladministration, if not the reality, leads to declining levels of public trust in government and its response. This is very marked if you look at something like Transparency International's Corruption Perceptions Index and the data which cover the period affected by the pandemic. And that's a composite indicator made up of global expert surveys of business leaders and data from the World Bank, World Economic Forum, and so on. The UK fell to its lowest level on the CPI just over a year ago and remains there at the moment, 71 out of 100. And the underlying data in that global data set point to increasing levels of concern among global business leaders about the way in which public money was spent during the pandemic, and a perception, and it is perception, that corrupt practice was fueling the diversion of public money. And I would argue that, again, that opacity, that lack of transparency is one of the things that fuels that.
You've identified in your evidence that there were shortcomings in the governance and the accountability of public contracting. What do you mean by that?
So, perhaps if I sort of talk to the guardrails that we would identify at two different levels, if you look at the statutory and common law frameworks, the relevant areas that we would have an interest in would be legislation around fraud, the Bribery Act, the common law offence of misconduct in public office, and then perhaps most relevant on the day-to-day basis in the pandemic response would be the guardrails around maladministration. Therefore, at the time, the public contracting recommendations, the codes applicable to ministers and civil servants, and more recently the nascent work of the COVID Anti-Corruption Commissioner. But during the period of the pandemic, when the public contracting regulations still applied in their form then, you could see that there was against those regulations, there was a collapse in the transparency requirements around the publication of contract notices within 30 days, and there was this immense strain on the management of conflicts of interest. And I think, if I may refer to paragraph 34 of our evidence, there's an interesting nuance in the Cabinet Office's first public procurement note in 2020, which is that which authorised the exceptional use of direct awards in the context of the emergency. But importantly, whilst those rules on the procurement process were relaxed, the rules on handling conflicts of interest should still have applied. But in practice, I think when we take our evidence in the round, you can see how they were immensely strained and how the again, the transparency regime saw this significant collapse with no consequence, really. And that's one of those deficiencies, is that the enforceability of it is very weak.
Can I just interrupt? I'm sorry, Mr. Chairman.
Yes.
In relation, for those of us not familiar with transparency notices, is there much involved in preparing for publication a transparency notice about a contract that's been awarded?
Thank you, my lady. I confess to never having prepared one myself
Right.
in my line of work, so I can't comment authoritatively, perhaps on the level of effort. But if I could perhaps offer some systems observations that come out of our research and our submission, which is that going into the pandemic, essentially the UK still had quite an analogue system that was very vulnerable to human error and misapplication of information. We may come onto that later. It's a slightly separate issue, but we didn't have a centralized digital common data standard system that allowed for those contract notices to be published rapidly in an easily readable, transparent way. So I think my contention would be that it's as much about the mechanisms that government did or did not have in place to allow those contracts to be published rapidly, as much as it was about the time involved. There is data, however, in our submission, which is quite telling, though, which is that COVID-related contract notices were subject to a materially much longer delay than all other public contracting notices during the period, and it's a very statistically significant variation, and we think it's important to get to the bottom of why that was the case.
What would you say to the suggestion that during the course of an emergency such as the pandemic was, that the priority was to get PPE and other equipment out to the front line, and that the preparation and publication of transparency notices and the like had to play second fiddle to it?
I think I'd refer to my previous answer, in that if we had a system in place that made publication of transparency notices easier, centralised, more digitised, it shouldn't even have been an issue that the UK found itself in this situation. More broadly, I would suggest that all of our evidence, and much of that already in the public domain, really challenges the narrative that all of the things that we contend went wrong with procurement in the UK's pandemic response were because government had to act at speed and essentially it had to cut corners. One of the reasons I contest that narrative is because so much of what we have found between us spanned months and months and months and well into 2022, with a tail end of data going into 2023, and compared to our peer countries on matters of transparency, on matters of spend, on matters of how long emergency direct procurement was being used, the UK found itself as an outlier.
So is your point that the emergency was deemed to last longer than it in fact did?
I think it is a matter of fact that emergency procurement exemptions were used for a considerably long period of time, particularly the direct award of contracts, and then those are intertwined with some of the other corruption risk factors that we identify in Transparency International's Behind the Masks research. But moreover, one of the checks and balances, one of the safeguards against misuse or maladministration of the emergency procurement mechanisms is the transparency regime. And again, the failure to publish contracts was a sustained problem for the entirety of our sample period. And to this day, there remain £5 billion of unpublished contracts for PPE and other supplies, 5 years after the pandemic struck.
Turning to another subject, please. Corruption red flags and the 135 contracts which have been subject to examination by the UK ACC. first of all, what are the corruption red flags and why do they matter?
Thank you. So this is the work conducted in Transparency International's Behind the Mask research, and its forerunner track and trace publication from April 2021. We developed, drawing upon international procurement best practice from the likes of the Organisation for Economic Cooperation and Development, a list of 14 different red flags against which to sift all of the government contracting data that we could find for our sample. We've grouped them, perhaps if that's a more expeditious response, into themes rather than me listing all 14, if that's the appropriate way to navigate it, around risks in the procurement process, risks in the supplier profile, poor contract outcomes, so concerns around failure to deliver or past record of suppliers. And then the 14th red flag would be an additional red flag if we found contracts that had risks in all of those areas. So some of the nuances that we would be looking for in those themes would be politically connected companies. They would be newly formed companies, less than 100 days old, so-called micro suppliers with balance sheets under 600 or turnover under £600,000 with no prior track record. Those contracts, in addition to those factors that were channeled through the so-called high priority or VIP lane for triaging of offers.
And those red flags, I understand, affected 135 contracts. And what was the total value of those contracts?
Yeah, so for context, the contract sample size was 5,000 contracts. That amounted to a total of £45 billion of spending, largely on PPE and testing, and a few other areas as well. So 135 of the 5,000 as a sample is relatively small, but as a volume of spend, it's very material because the 135 constitute £15 billion, so broadly a third of the sample. And I can't stress enough that this is the most comprehensive data set of its kind that puts all of these contracts through the corruption risk red flag filter. It's a more comprehensive data set than the government has available to itself on this area.
Of the red flags that UK ACC have identified, you've described the company being relatively new, contracts being awarded without competition, the supplier being a small entity, the company being politically connected. Given the systems that were in place at the time to look at these issues, what are the kinds of guardrails that you and UK ACC would have expected to be in place in the contract progress and award system?
Yes, probably the most relevant test that we believe should have been being applied was the 8-step due diligence process that has been referred to in previous reports, I think, from government, and is referenced in our research on this area, that in theory should have picked up some of the types of red flags that we've identified in our research, along with the landscape of the public contracting regulations at the time, and, for example, its obligations on effective management of conflict of interests where they're deemed to exist. I think what the data show is that there are this very high number in volume of contracts that had a significant number of red flags, and it's perhaps worth stressing that, you know, the list of 135 is the 3 or more threshold. The top couple of dozen of contracts had up to 8 red flags, and those are, and I don't think it's constructive to name those companies in this context, because I don't want to prejudice any other ongoing proceedings which may involve them, but there should have been multiple opportunities using that due diligence process, using the obligations upon civil servants and indeed the politicians who are involved, as we now know, in referrals, to identify some of these red flags. That should have probably caused a contract to stop. Examples being, something with an opaque ownership structure that's non-competitively awarded, that's clearly brand new, there's no former track record, and it would appear that that contract is only being placed on the desk of a civil servant because it's come through the high priority lane. There are multiple examples in the underlying data set where those things should have been stopped. It's not clear to us, and we haven't been able to establish why they weren't.
You, via UK ACC, have conducted a large volume of research on Contracts Finder. Could you please help us with what Contracts Finder is?
So Contracts Finder is the UK government's, one of the UK government's contract publication tools. And in the context of the pandemic, it should be looked at alongside TED, which was Tenders Electronic Daily, which was the centralised EU contracts publication platform. In both cases, the data are rarely beautifully complete. So the analysis that we produced through TI, through Open Contracting Partnership and our coalition, needs to be understood with that cautionary note. One of the challenges that we saw in analysing data from Contracts Finder and Tenders Electronic Daily in this crossover coming out of the EU period was a lot of contract duplication, which was then further exacerbated by a lot of human error that I've referred to in terms of the contract information that was put into Contracts Finder, taken together when we looked at our sample of 5,000. If we just added all of those together and not manually sifted out all of the duplication, it actually looks like government spent £30 billion more than it had on the pandemic response. So that's perhaps a separate point around the sort of cleanliness of data and how we action that going forward. But it's important in the context of understanding how fragmented and chaotic pandemic-related procurement data is on Contracts Finder and elsewhere.
So you found, UK ACC found inflated contract values, missing data, misspelt contractor names, and other inaccuracies. And has that made your analysis of the contract data more difficult?
Oh, yes, undoubtedly. And when we talk about inflated contract values, sometimes the differences that we're talking about are an official typing millions when the contract was actually billions, or vice versa. And again, we assume human error. The Ministry of Defence had 3 or 4 different departmental identifiers in the data set. Sometimes it's just a spelling error, swapping out the C for an S and things like that. These might seem like slightly geeky technical points to be raising, but they're incredibly important when it comes to us having a public spending transparency repository of information that we can rely upon, that builds trust, and again, coming back to my earlier point, is usable for government and suppliers.
Can I turn, please, to some international comparisons which the UK ACC has done with the Open Contracting Partnership? We heard evidence from Professor Sanchez-Graels this morning that he hadn't been able to find another country with a high priority lane or a high priority lane-like system. Have you been able to find anything like that in your research?
No. We come to the same conclusion as the professor. We cross-checked peer countries. We consulted with Transparency International chapters in around 100 other countries. The Open Contracting Partnership consulted with its network in 30 countries, and it appears that the high priority lane, the so-called VIP lane, was a completely unique feature to the UK's pandemic response.
You refer in your witness statement to a World Bank survey of 103 countries and an assessment of the accountability and transparency standards in those countries. How does the UK compare to those 103 countries?
I think almost exclusively in the World Bank survey, all countries experienced degrees of challenges with their pandemic procurement in what was an incredibly hot market. There were pockets of corruption scandal in other peer countries. Germany, for example, various sort of political scandals around contracts awarded to those connected to government, particularly again in those earlier weeks and months of the crisis. Where the UK stands out is the length of time, as I've laboured before, that many of the measures that were being used, many of the affronts to the transparency regime and the spirit of the public contracting regulations were sustained for, but also the manner in which, relative to its European peers, the UK procured an extraordinarily larger amount of PPE and other supplies, and again relied very, very heavily by contract volume on the use of direct awards in a way that was only replicated in terms of the European peers in places like Cyprus and Luxembourg, so much smaller nations with a collective population of only around 2 million. The other thing that the UK seemed to fail to do relative to other peer countries, similar comparable countries, was to stop and learn as it went. Lithuania, for example, was having difficulties with its procurement, was struggling with price inflation, was struggling to keep on top of its transparency obligations, and around about the middle of 2020 did a sort of stop and review exercise to make some adjustments to the public transparency regime, to stock take on pricing data, and so on. Whereas the UK at that point, when you look at the data which speak for themselves in our assessment, still looked like a runaway train of spending and opacity.
Can I just pick up on 2 points which you've made, perhaps with the assistance of some graphics? Could we have up, please, INQ 474994? And the bottom of page 4. Thank you. If we can just zoom into that graphic at the bottom. This is a chart about the proportion of direct COVID contract award notices by country, 2020 to 2021. The countries are listed on the bottom: Germany, Spain, France, Italy, Netherlands, Poland, and then the UK on the right-hand side. And in terms of direct contract award notices, the UK seems to award, by direct contract award, about double that of Germany, doesn't it?
Yes, that's absolutely correct. Perhaps the most comparable data set within this, which is where colleagues at OCP started with this analysis, is to compare Germany, the UK, France, and Poland on the basis of similar levels of size of population. Because, as I mentioned earlier, smaller nation states like Cyprus and Luxembourg, it can be a bit distorting if you've got a smaller population. So relative to those immediate peers and this slightly wider sample, which we see in the evidence, yes, the UK is very substantially over the period. I believe this data, yes, runs to the end of 2021. So again, a long sample from the pandemic is relying very heavily on the use of direct awards, which in itself is one of the corruption red flag risks that we would identify.
Another graphic, if we may, please, to deal with your second point. 474994, the graph on the top of page 6, please. This is your UK ACC's analysis of the COVID contract notices, a cumulative total, and at the top, an outlier by any standard is the UK, with all the other countries, Germany, Spain, France, Italy and Poland, down at the bottom.
Exactly. This is all COVID-related contracts that my colleagues at OCP could find for all countries, again, using data from Tenders Electronic Daily and Contracts Finder. I think the data speak for themselves in terms of what this is telling us, but there is something particularly unique about the amount of money that the UK spent on COVID contracting relative, again, to peer countries, many with similar-sized populations in Europe. I think it's really important to look at this data in parallel with the other issues that we've already discussed, as well, as we start to sort of build a picture of the UK's response. So here you have this enormous variance in the amount of public money that is being spent, with that enormous variance in the use of direct awards that we've just seen, with a VIP lane that was completely unique to the UK, and with a notable collapse in public transparency around public spending, all into this sort of melting pot of issues which characterise the UK's response, and I think leads to some of the wider questions that this inquiry will need to seek to answer over the weeks ahead.
One of the comparisons which you draw is between the UK and Canada on the approach to the call to arms, being a public call for the provision of healthcare equipment and supplies. Could you help us, please, with the differences between the way that the UK approached that problem of open sourcing procurement and the way that Canada dealt with the same issue?
Canada, I suppose, going into the pandemic was already greatly advantaged by the fact that it had a mature, well-resourced, digitally savvy, centralised government procurement service, for want of a better term. It's called Buy and Sell Canada. So that was there and poised and ready to go. With that infrastructure, what Canada was able to do was to take an approach that went to market for PPE and other products, testing and so on, with very clear, well-publicised, well-detailed specifications of this is what we need as government through our centralised procurement platform, and was able to go to market with that very transparently, very quickly, and had a system in place that allowed suppliers to then put in their offers and their bids that was based upon approaches. This is what we need. Can you fill this need, and how much is it going to cost? With transparency baked into that approach and publication of as much of that data as possible throughout. The UK's approach feels in many ways inverse, in that the so-called call to arms for PPE and other supplies felt like a tell us what you've got and we'll work out what we want to buy, leading to this overwhelming volume of offers that government was struggling with just managing the data for in those early weeks and months of the crisis, and therefore the introduction of measures to get through all of that data, which in our assessment only increased the risks of corruption or maladministration rather than reducing them, whereas Canada was sort of tanking along, buying the things that it wanted to buy, and there was this marketplace, if you like, where buyers and suppliers could see each other. To come back to my opening remarks, that ability for good transparency to lead to better procurement and better buying capacity at the outset was greatly advantaged by systems such as this.
Would you agree that the approach, at least from your analysis in the UK, was to say that tell us what you've got was the UK's approach and this is what we need, in short, was Canada's approach?
Yes.
What, from your analysis, do you think could be learned in this country and in the devolved administrations about the approach to procurement from the experience of Canada?
Well, I think at an overarching level, the need for investment in procurement expertise that is centralised and becomes a more professional cross-government function in and of itself. The need for digitised platforms and tools that work and that are fit for purpose, both in terms of publishing contract opportunities and then the follow-up transparency data that we have discussed. And a few other areas as well, which are evident in Canada and other countries, such as Germany, Lithuania again, Paraguay had much innovation in its procurement response. Tools such as the use of mini frameworks, which the UK doesn't use, but the ability to quickly put together groups of properly screened suppliers. Germany had an approach where it did this and had a sort of take it or leave it approach on pricing, where the federal government would say, well, that's what we're willing to pay for this, and let's leave that standing there for when we need it. The framework situation in the UK is much more cumbersome and is perhaps one of the underlying challenges that led into the barriers that government was facing when we went into the pandemic. I know there is a
Pause there for a moment. What do you mean by cumbersome? In what ways was it cumbersome?
So the UK generally relies on closed frameworks rather than open frameworks, and I think this might be behind some of the challenges that SCCL, Supply Chain Services, experienced and seemingly led to its kind of notional collapse early on in the pandemic. In that, periodically, the UK government will go to a market in any department for suppliers of X or Y, so that there is a pre-approved bench of companies who can provide the types of things that that department needs to procure, and then that framework is locked off for a few years. Usually you get your framework agreement in place as a supplier. It protects you in that select group for a few years. It doesn't normally set pricing information. That would come later at the call-off point if government was to go to its framework for that particular area. It's very rare that government adds in suppliers to its frameworks, whereas mini or open frameworks allow that to happen quickly. And as we can see in places like Paraguay and Germany, they could be stood up quite quickly in the context of the pandemic.
So I'm not following the standard framework that we use. Every so often, we're going to recognise you, Mr. Supplier or Mrs. Supplier, and you go onto our list. And the advantage there is that they've already been through a process of validation. Do you not lose that established process of validation if you have more open frameworks and mini frameworks that you've just been describing?
Thank you, my lady. So your interpretation of my evidence is correct. I don't think we would contend that is the case. That I think those things we can see from some of the evidence can coexist side by side. Much of this for the UK, though, would be resolved with the other procurement recommendations that we and others have made in terms of systems and investment and training and different types of mechanisms beyond these cumbersome frameworks. But I think that, again, you can just see in other international comparisons that other countries came up with nimble, effective solutions faster and quicker that cost less.
Can I just, sorry to pursue again, going back to the point you made about Canada and its much, you said, digitally savvy system for data analysis. Whenever I make a recommendation in a time of constrained resources, I always have to try and find a way whereupon it could be something could be used in peacetime, or it's something that would be spent to save. I think the professor earlier suggested this could be quite expensive if this were a recommendation. Better training, better data system. Have you anything to say that would help me make a recommendation that might be persuasive for a government faced with difficult resources?
I'm afraid I can only hypothesise, my lady. Our suggestion would be that we would agree with the professor that better procurement systems need investment, and it will need investment in systems technology and training in particular. The benefits that, and here's my hypothesis, the benefits that should flow from that will be delivered in the years that followed that investment. And again, not all of the countries in the OCP sample necessarily have the best digital platforms, but I just come back to that pattern of massive spending by the UK government using the tools that it did or didn't have at its disposal in the pandemic. And I think that's, for me, as a data point alone, enough to say that actually if this was to happen again, or some other crisis of this magnitude, would we really want to have the UK as such an outlier on how much money it's spent? So again, I'm hypothesizing, forgive me, but I think the returns come in later years.
Thank you.
Could I turn, please, to just a few of the recommendations which the UK ACC makes, in addition to investment in a procurement system and development of procurement professionals. One of them relates to conflicts of interest and an observation that you make about the implementation of the recommendations of the Boardman Review, which we heard about earlier this morning. Could you help us, please, with what UK ACC's view is of the implementation of recommendations about conflicts of interest from the Boardman Review?
Thank you. Our understanding at the time was that government accepted the two sets of Boardman recommendations in full. They haven't yet been implemented in full, and perhaps the most salient point in this context is the conflict of interest policy work. Only two of many more government departments had overhauled their conflict of interest policy in light of the Boardman recommendations. The rest, last time our coalition checked, remained unaddressed. I think we would go further in our recommendations and suggest that you don't have a department by department conflict of interest policy. You just have a single policy for conflict of interest management as it relates to procurement for government departments. There are other areas of Nigel Boardman's recommendations which remain unaddressed and which are still salient today. One of them comes back to the point that we were just discussing around training. At the minute, many civil servants have a sort of mandatory 10 hours online training on procurement and conflict of interest management, and this needs to be more substantial going forward. And there are various other sort of smaller details around getting alignment between the way that conflicts of interest are published and declared, and again introducing more transparency into that regime. So one of the recommendations we make, which builds upon Nigel Boardman's recommendations, is that when public contracts are being entered into, it shouldn't be just enough in future to confirm that a conflict of interest assessment has been conducted, but that assessment should be published as part of the disclosure regime, for example. And perhaps finally on this point, our recommendations, I believe, are aligned in that we suggest that suppliers should have matching conflict of interest policies and management, as well as those within the government department that they are contracting with.
Mr. Bruce, thank you. My lady, unless you have any further questions.
No, just another question, Mr. Bruce. Going back to your point about companies that have really only just been set up, as a non-expert in procurement, I would expect that any form, or I gather it was a SurveyMonkey result, almost the very first question was, when was your company established? And that if it was within the last few months, I'd be very wary. Do you know if that's a principle that anybody thought of? It just seems so obvious.
I don't know if it was on the SurveyMonkey, because I didn't see the SurveyMonkey that was used for gathering contract data. I mean, I think it's part of the wider landscape of the attitude towards these controls, and if of public spending in the pandemic, and if there is one aspect of the UK government's response, which in our assessment was the most egregious, it was the creation of the high priority lane, the so-called VIP lane. As I've said, other countries had their pockets of scandal. The UK government, in essence, ended up creating a system that invited corruption risk that flew in the face of all international best practice and threw the rule book out of the window. It must never happen again. The then Labour Party in opposition suggested they would legislate to make such VIP lanes unlawful in the new Procurement Act. That hasn't happened yet. But if we look at actually the loss and the write-offs associated with the high priority lane, contracts that were 80% more expensive for PPE for all companies going through the high priority lane, £1 billion representing 59% of spend on PPE written off as not fit for purpose. That, if I can implore one thing, that is the biggest lesson that we must learn from the UK's approach to procurement, because all of the details around the information that was being collected or not able to be collected, and then the collapse in transparency was only further exacerbated by the creation of the VIP lane.
Message received.
Thank you, my lady.
Thank you very much indeed. Oh, no, we've got Mr Weatherby. I think you've got some questions.
Yes.
Sorry, Mr Weatherby has some questions for you.
Thank you. I ask questions on behalf of COVID Bereaved Families for Justice UK. Just 3 short points on something you nearly finished on, conflicts of interest. So in your witness statement, or the statement that you adopted, for the record, paragraph 51, it stated that the UK government's approach to emergency contracting had effectively turned ordinary rules on handling conflicts of interest on their head. Personal relationships resulted in suppliers going through the high priority lane rather than being used as grounds to more carefully scrutinise suppliers and record decision-making processes. So my questions are, firstly, do you consider that commercial or personal links between a referrer of an offer and a supplier in the VIP lane were in principle capable of constituting a conflict of interest?
Yes, we do.
Do you consider that in ensuring that a fair system of procurement required proactive disclosures of conflicts of interest by both referrers as well as suppliers?
Well, I think that's a caveated yes, because the language of referrers and suppliers is again germane of the high priority lane approach, and in the context of my remarks a moment ago that we think that approach should never be repeated again in the UK. We would rather you didn't have to retrofit such controls to such an approach, because we'd rather it didn't exist.
Yes, my question was rather prefaced on that basis, but thank you for clarifying that. And it's the same caveat here. But if yes, do you consider that in practical terms, referrers should have been required to disclose any conflicts of interest at the point of making the referrals to the high priority lane? Same caveat.
Again, the same caveat. Yeah. I mean, in hindsight, in retrospect, yes, in the context of that system having been chosen to be the system that was used.
Indeed. Thank you very much.
Thank you.
Thank you, Mr Brett. That completes the questions that we have for you, Mr Bruce. Thank you very much indeed to you and to your colleague for the written statements you prepared. And thank you so much for all your help today. You're a very good advocate for your cause, if I may say so.
Thank you, my lady.
Thank you. I think we'll carry on, Mr Charlotte. It's a bit early to take the break now. If you'd like to take the oath.
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, please.
Thank you.
I hope you were warned you'll be on later this afternoon.
No, not a problem.
Sorry to keep you waiting.
Could you start, please, by stating your full name for the inquiry?
Yes, Gareth Rees-Williams.
Is that how you would prefer to be referred to, Sir Gareth?
Yeah, that's fine. Thank you.
Do that.
Sorry, I've been through this before with another witness. Was the question meant to be whether you want to be Sir Gareth?
Yes.
No, you accept a knighthood, you get called Sir Gareth. I'm afraid I pointed that out to Sir Christopher Wormald.
Then Sir Gareth it is. Sir Gareth, you have, and we're grateful for it, provided to the inquiry a number of witness statements. A corporate Cabinet Office witness statement dated the 5th of July, INQ 000497031. A witness statement dated the 14th of January 2025, which is inquiry 000536362. And inquiry document 000535017, a further witness statement dated the 23rd of January 2025. Is that right?
Yes, for fullness, there was I did one also for Module 1, but that was much smaller. That was more of a summary for everybody.
Yes, those are the three that we're focused on within this module.
Yes.
Can you confirm, and I believe you have done with your signature, that the contents of those statements are true to the best of your knowledge and belief?
They are.
And there are, in addition, a number of statements that have been provided to us by Claire Gibbs, a corporate statement on behalf of the Crown Commercial Service, INQ 000528389, dated the 20th of December 2024, and an additional statement by Claire Gibbs, INQ 000569124, dated the 28th of January 2025. Can you confirm that you've read those statements?
Yes, I think the first that you mentioned was a Cabinet Office statement, not a CCS statement. Mrs. Gibbs took over after I left the civil service.
Very
So
well.
Gareth, can I apologise? I should have checked my facts. You didn't accept a knighthood, did you? I'm
would
really
never have
sorry that
dreamt
I
to,
caused that confusion. Please forgive me.
I'd never have dreamt to.
Where are we
to-
left?
We're left with... if you're a baronet, I still think you're Sir Gareth, but it's,
Okay.
it's certainly up to the witness.
Whatever, I'm here.
Mr.
Teach me to be a
Rees-Williams,
pedant, won't it, really?
you left the Cabinet Office in 2024 and are now the Chair of National Highways.
Correct.
You're a chartered engineer by background with a wealth of experience managing a variety of companies and more specifically in so-called just-in-time operations and continuous improvement.
Yep.
That's right. Very briefly, we'll turn to the concept of just-in-time operations next week with a further expert witness that's appearing on Monday. But in the meantime, would you, if you wouldn't mind, very briefly, explain what is meant by those terms, just-in-time operations and continuous improvement?
Well, to take the latter first, and I think it is an ethos I've tried to engender in the commercial function. Continuous improvement is vital to get better and better and better and take every opportunity to learn things across a system. And that goes to the heart of the way that the commercial function has been structured up until now. I don't know if you're going to come back to that. In terms of just-in-time, that's a study, a methodology initiated in Japan about driving out waste out of a production system or an office system, really by focusing on not making more than you need, moving it as fast as you can, and having the least inventory within a factory. That is slightly different from least inventory in a finished goods environment. So to take an easy example, cars, factories are very just in time, but we've all seen plenty of garages with lots of cars on the forecourt. So I spent my early career working on manufacturing systems, how to make things quickly and scale things up quickly. That's perhaps the relevant bit.
Thank you. Moving forward then to the pandemic. During the pandemic, you were the government chief commercial officer, weren't you?
Correct.
And you held that position between March 2016 up until July of 2024.
Correct.
Yeah. What did that role entail in brief terms, if you would?
So two sides to that. The first side, I was one of the what's called the functional leader, introduced into government in order to try to drive professionalism, in my case in the commercial function, but there are colleagues in projects, colleagues in digital, colleagues in HR who are doing much the same. So that's about how do we recruit better people, how do we train them, how do we retain them, and back to the continuous improvement point that Mr. Walds raised, how do we learn from each other so that we don't make the same mistake again, or how do we learn from each other by taking good practice in one part of the government network and spread it around the others. Government is hugely siloed. You've probably heard that before, and that things don't easily move from one department to another.
Well, we'll come on to
So
that.
that capability is one side of the role, and the other side of the role is really, I was the face of government towards its suppliers, and of course, I mean, we've had tens of thousands of suppliers, so the more senior suppliers, I had a relationship with, and I was brought into senior fora if there was a question of how would the supply base, how would industry feel about ...
I want to come on to the government commercial function. We've heard in previous modules about the role of the Cabinet Office in government decision-making generally and in respect of civil emergencies. In this module, with your help, we want to focus on the government commercial function. It's a cross-government network of staff based in all departments who procure or support the procurement of goods and services for the public sector, amongst other tasks. Is that right?
Yes, would you like me to expand on the structure?
Well, I'm going to ask
Okay.
you to do that in a moment by reference to a graph that is included within your evidence. Before I do that, I just want to get a sense of the scale of it in terms of staffing. The Cabinet Office employs a senior cadre of the government commercial function numbering about 1,500 staff. Is that right?
Yes, so of the, roughly speaking, 6,000 people in the commercial function across central government, and we perhaps need to come back to delineate that because at the time, well, and as of now, it doesn't formally include the NHS, and at the time of the pandemic didn't include some other arm's length bodies that have since been moved into it. But of that total 6,000, who are 4,500 broadly, are employed directly in their departments like any other civil servant working in their department. There's the management layer from what's called grade 7 and upwards. I don't if you'd like me to explain that. But from grade 7 upwards are contracted centrally, albeit they actually work in the Ministry of Justice or the Home Office or, in this case, DHSC. So they are formally employed by the Cabinet Office and therefore in the structure that I led. And therefore, that is the glue that has enabled us to drive through common training, common methods, learning from each other, which otherwise in a siloed structure such as we have in government is very, very difficult to execute. And that structure is similar to what you see in the government legal department in that they have a central group, but then people deployed in each department, except I'm subject to everyone in this room correcting me. GLD is all of the lawyers, whereas the commercial function is just the GCO, this senior 1,500, it was about 1,000 at the time of the pandemic, are just the leadership grades of it.
Now, I promised I'd come to and display, if I can, one of the visualizations, the graphs within your evidence. It's INQ 000497031, which features at page 32 of your corporate statement, paragraph 220. See if we can get that up on the screen now, and whether it might assist. Were you thinking of that a moment ago?
That's what I was starting. Yeah.
Yes. Does this help us understand anything further than that which you've already explained?
Yes, it does a little bit. And the red, so the blue, the government commercial function, 6,000 people. Everything on the slide, milady. The red, the GCO, the management layer. So it's a graphic. It doesn't cover just the words that are inside the red loop. I'm trying to indicate, the seniority of the people. I think what is important here to understand, perhaps for the inquiry, is who does what. Because the Cabinet Office is a complicated word in the procurement structure. So is it useful to take you through the 3 columns?
Well, it would be to the extent that it will help us understand this issue of siloing that you mentioned a moment ago.
Okay, so in the department, so on the left-hand column, the Home Office buys very different things from the Ministry of Defence, different from the Ministry of Justice. Those teams should buy the things that are specific to them, prisons or warships or whatever it is. Other people should not be buying those. That should be for the obvious department. The Crown Commercial Service in the middle, which is also an ALB of the Cabinet Office, hangs off the Cabinet Office, puts in place the frameworks that you've heard a lot about today for what are called common goods and services, things that one would normally expect everybody would want to buy. And the obvious example is buildings. Everybody has buildings. It makes no sense at all for 20-odd departments each to develop a skill in buildings procurement. Much better that CCS, Crown Commercial Service, generate a framework, and then everyone else pulls off from that. And you've heard about similar, or we could talk about the NHS structure in a second if that's helpful. In the Cabinet Office, there are 2 things. There are the 5 central teams, we've rationalised them since, that lent people, as has been discussed today and we'll probably get back into, who were then deployed out into departments to staff the PPE team, the test and trace team, and the ventilator team. But there is also a version of the left-hand column, because the Cabinet Office, of course, has its own procurement team that does not work for me, or it works for me in the functional sense, but it works for the Permanent Secretary, for the ministers in the Cabinet Office. So they're included in the left-hand column. Is that helpful?
It is. I want to move us with that helpful background to the role of the Cabinet Office in PPE procurement. Can we move on to that now? Now, if I'm right, aren't I, that whilst it was the DHSC that was the procuring department for PPE, it was the Cabinet Office staff that had close involvement?
Yes, and that's because when we think about COVID procurement, my lady, we need to recognise that these are and procurements. All the other underlying work of government needed to continue happening, prisons, IT buying, whatever it was, schools, building, whatever it was, that still needed to happen. And for reasons you heard earlier, SSEL ran out of staff, IT and so on. DH had been through, as I recall, a pretty savage downsizing a couple of years beforehand, and that slightly goes to the staffing issues that the professor talked about in SSCL. We might come back to that. And so the only pool of spare people that we had, apart from the people I could, frankly, ask for and encourage colleagues in departments that I felt would be less loaded than others, was the complex transactions team and the market, to a lesser extent, the markets and suppliers team, who worked directly for me, but in the Cabinet Office. And we were able to, they're very high-level people, very experienced, skillful. We were able to move them over immediately because they worked for me and I could just do that and take them away from whatever else they were doing, supplemented by resource from the MOD, which I couldn't directly control, but they were good to volunteer, DFE, and other government departments where I was able to encourage them to be released. And that between them and staff from the commercial staff from the NHS, that's what made up the PPE cell team.
Mr. Rhys-Williams, you referred to the professor. You're talking about Professor Sanchez Graels of this morning.
Yes.
You heard his evidence. Did you hear it?
Yes.
You did? Oh, good, because I'm going to come back to it. It's useful to know that you heard it. I want first, though, to ask you about the complex transactions team and how that fits into the organogram that you've been explaining to us, there was such a team, wasn't there, which assisted. Now, in brief terms, what was the team for and what did it do?
Okay, they were in the right-hand column of the graphic you just put up, somewhere in that column. So they're a team of 35-ish, plus or minus, of senior, experienced commercial staff. So generally at what's called senior senior civil servant level 1, or the equivalent in the GCO structure. They didn't have lots of people working for them. These are an internal consultancy arm that we would essentially rent out. Departments could ask for help for things that a dispute, a complex negotiation, a complex piece of strategy, where it would make no economic sense for the government, that government department to have that resource on hand year in, year out. If they needed it for 6 months, they could borrow and pay for one of the people in the CTT in order to support that. And then at the end of that assignment, those people would then come back into the Cabinet Office pool. In the meanwhile, they would be working in the Home Office or Department for Education or wherever it was, under the direction of the local commercial director or chief operating officer in whichever department was hiring them.
Cabinet Office staff were involved in setting up the PPE buy cell, also known as the parallel supply chain, weren't they?
Yes.
And we heard something about that earlier today with Professor Sanchez-Claels. During the course of the pandemic, you were also involved in a number of key decisions and commissioned reviews regarding the high priority lane, prices and processes, weren't you?
Yes.
Examples of those are the 2 GIAA reports, 1 and 2.
Yes. During that summer, there was increasing noise in the press about these PPE contracts, what's going on. And as I cover in, I think, one of my submissions to my lady, some of those contracts were placed with companies that on the face of it, you look at it, you go, why would you buy PPE from a pest eradication company? Well, because actually those people who do that sort of work wear PPE, and so that's why they were able to help. But there were a number of issues like that, and questions on pricing, questions on so on and so forth. And I thought, at the time, and now I didn't think anything was going wrong, but these things need checking. So I asked, I was not allowed to commission GIAA myself, but I persuaded Alex Chisholm, who was then the Permanent Secretary, that he should commission GIAA to look at, and I said, pick 6 contracts that have been in the news, you choose, dive into them, discover what you can. When they did that, I said, fine, okay, that we'll perhaps come on to their findings in a minute.
Well,
I asked them
not
to
in
do
a
another
minute,
6.
but we will come on to them.
Okay.
Yeah.
I also commissioned, the first thing I commissioned was actually a pricing analysis. So the big concern, if there's bias, favoritism, cronyism, which was what was being alleged, was there might be a pricing advantage to the people that have been thus favoured. At the time, we were using an external consultancy called Officio to analyse the contract data and plot pricing. That's an exhibit you've got to look at the pricing by category.
Mr. Rees-Williams, can I rein you in a little bit? We are going to come on to the GIA reports. Mm-hmm. And if at that point you wish to make points about the pricing analysis, you'll be free to do so. I don't want to really go there right now. Is that all right? Mm. Thank you. The Cabinet Office and Number 10 also had some overview of the DHSC's procurement activities as PPE updates were given to the Prime Minister on a regular basis. That's right, isn't it?
Yes, but I didn't see those. That was Emily Lawson and her team would present that directly to the...
You never attended those meetings?
Never might be too sure, but I think never actually. But no, I don't think at all.
And there were cross-departmental discussions about the sourcing and distribution of PPE, which presumably you did attend?
No, I had no input on distribution at all. So
sourcing and distribution.
Sourcing, I work with a colleague, Rob Nixon, who's one of the CTT people who drafted the first sourcing roadmap, when SSCL's suppliers, who are, as we discussed earlier, mainly distributors based in the UK, ran out of stock, we needed to rapidly work out who the underlying manufacturers were, such that we could then approach them. And Rob did a piece of very quick work on that, and I discussed that with him, and that then became a cornerstone of the work that Emily Lawson took over and fed into the China buy. So I was involved in that, but that was right at the start.
All right.
I would say almost, Rob did the work, I would say almost my involvement was de minimis on that. But just
You tell us at excuse me.
I think between sourcing and distribution is the important point about volume. So DH were the contracting party. They were the people with the forecasting ability. It was their forecasts that then the buy-sell was just told to execute. And it's not really the place for procurement people to decide how many tanks the army wants. Or they say how many they want, and then the procurement team's job is to find those in the most effective way they can do. So again, I don't think any of us were involved in that demand framing.
All right, let's touch now, if we can, on the scale of the challenge that you and others faced in terms of procurement when the pandemic arrived. You tell us at paragraph 8.1 that the scale of the challenge that the pandemic posed was unique in peacetime. The scope and intensity of procurement activity that was undertaken across government to meet this challenge was therefore substantial and underpinned our ability as a country to combat the virus, to allow the NHS to continue to function, and ultimately to protect the public. Yeah.
I don't know. I think, is that from my CWS?
Those are your words, yes.
Yeah.
Paragraph 8.1.
Okay.
Now, in terms of a visualisation to help us understand this, the scale of procurement activity, I wonder if we could have up on the screen INQ 00497031. It's your paragraph 1.22, page 8 of your corporate statement, and it shows us,
Yeah.
you know this.
Yes, I prepared this for the inquiry when we first met some of your colleagues.
Yes, and it shows us, does it not, that the greatest intensity of activity on PPE procurement ended, PPE procurement being the orange,
Yes.
end of June, beginning of July,
Yes.
with other testing carrying on beyond that. And we can see at much lower levels ventilators.
Well, ventilators was really a one-off in March and April.
In March and April, for which you had responsibility.
Yeah.
And in relation to which we'll be hearing evidence from you tomorrow rather than today. All right, that's
I think it's worth
Go on.
just explain. These I believe are contract dates. So the delivery dates, when it goes to some of the points that you were sort of touching on earlier, the delivery dates,
With Professor
particularly from
Sanchez
PP,
Graels.
well, and with the gentleman from Transparency International, so the delivery dates, of course, are a couple of months after that. This is contract placement dates, I believe.
Yes. Yes, there's some time lag between contract and arrival or deliveries, yeah. All right, let's turn to another topic now, please. This is helpful to understand the scale of procurement and the challenge. A topic that was touched on this morning with Professor Sanchez Graels, guidance. It became necessary, he told us, and I'm sure you will also tell us, during the pandemic, to issue guidance in the form of PPNs or procurement policy notes.
Yes, that was a standard way that predated the pandemic for getting policy information out, not just the central government, right across the public sector.
Yes. I'm conscious, my lady, I'm starting a new topic. I don't know whether that is a convenient moment to pause.
Certainly.
Yes.
Very well, I shall return at 3:30. All rise. Mr. Ward.
Thank you, my lady. Mr. Rhys-Williams, we had reached the topic of procurement guidance, which is one that I hope to be able to deal with relatively briefly with you. You'd agreed that during the pandemic it became necessary to issue, on a number of occasions, guidance by way of PPNs, procurement policy notices.
Yes.
Or notes. That guidance evolved as the pandemic progressed, didn't it?
Yes, in a number of different ways.
Yeah, but rooted within the guidance is the importance of observing the principles of public procurement regulation explained to us this morning by Professor Sanchez-Graels. That's right, isn't it?
Yes.
And he enumerated, there are 9 of them: predictability, effectiveness, economy, transparency, integrity, access, fairness, accountability, and capacity. And all of those are enshrined and are encouraged, whether or not procurement is conducted on an emergency basis or on a business as usual basis.
Yes, I think the key words that would be in the EU regs from which at the time our regulations were derived is fair, open, transparent.
Yes, those are the ones that Professor Sanchez-Graels alighted on as, these aren't his words, but non-negotiables. The others, he said, may need to be adapted in the light of emergency circumstances. But those of transparency and fairness, you would agree, need to be maintained whether or not one is procuring on an emergency basis.
Yeah, that's certainly the ideal.
In fact, one could go further. I wonder if you do. One could say that in an emergency where direct awards are made, it is all the more important to maintain and ensure that those principles of transparency and fairness are happening.
So let me take those two in 2 bits. So transparency, I think, is really important. And during my time in the Cabinet Office, we have been publishing more and more things outside of the regulations. For example, KPIs, because the performance indicators for a contract, because it's vital that the citizen feels that their money is being well spent, and it also helps drive competition. So transparency is good.
Mr. Rhys, can I don't want to in any way limit your answer, but can I just have an answer directly to what I asked? I just want your view, please. Those principles apply whether or not one is in an emergency. I'm suggesting, I'm inviting your view on whether they should apply all the more in an emergency. So, fairness and transparency.
So the reason I was separating them is I think they're slightly different. So transparency, there are additional requirements, rightly, as I said in my statement, and Professor Sanchez-Graels touched on it as well, the workload to publish correctly using Reg 32 is rightly larger and more onerous. Why have you done this outside of the rules? And
so is that a yes in that case?
Yes, that is a yes.
That's a yes. Okay.
So
on the other one, is it a yes or a no?
So there are two legal cases going on that were judged on during the period of the pandemic that go to legally whether, if you're operating under Reg 32, whether you need to be to generate competition and be fair. I forget the exact wording. As a point of principle, however, yes, if you can possibly generate competition, that is going to be fairer. And in my statement, I point to a number of examples, there are many, where even where we used Reg 32, we did generate a mini competition underneath the Reg 32 in order to drive out value for money, but also to allow other people to compete. But it was just done very quickly. And I think that we heard this morning about the 35 days minimum time, which just wasn't acceptable in a lot of cases. So I think my answers to transparency is yeah, absolutely. Fairness, if you can.
If you can.
Within a Reg 32
Then there's
context.
an enhanced requirement to achieve it in emergency conditions.
Transparency.
Transparency, yes. Fairness, if possible.
So there are conflicting legal judgments on this from a Public First case, which said if you're doing Reg 32, then you don't need to consider other angles. And then the case against Pesfix, bizarrely, because the government won it, we weren't able to challenge the ground of whether, I don't think the word used was, for equality of treatment was something we needed to test. But I deferred to the legal profession on that.
Right.
But from a point of view of getting the best value for money, the best deal for taxpayers, then yes, the more fairness you can introduce, the more competition you can introduce, obviously the better.
Some of the guidance that was issued during the pandemic related to ministerial involvement in procurement, didn't it?
Yes, so it was towards the end.
Wait for the question, please. Your evidence contains a number of references to the pressure that was brought to bear on those responsible for procurement due to ministerial pressure, doesn't it? We'll come on to the detail of that in a moment.
So
Is that a yes or no, and then whatever elaboration you choose?
yes, but with a couple of caveats. And I think the pressure can take several forms. And a minister chasing, have you done this yet, is one thing. Their office, more usually, chasing up, you said you would have done this by now, have you? That is also annoying but fair. That is very different from a minister saying, buy this from them, which is not right. And in my experience, that only happened to me in one situation, which I suspect we'll discuss tomorrow.
We'll be hearing in due course from Mr. Canduff and Mr. Hall. They had more of the day-to-day experience.
That's right. I wasn't involved in the high priority lane day-to-day at all.
You weren't involved in the high priority lane day-to-day. So far as ministerial pressure is concerned and its impact within the high priority lane, those witnesses will be able to give more direct evidence to this inquiry.
Absolutely.
Yeah. So let me come to my question then. The guidance that was issued in relation to ministerial involvement on procurement, did that come about in order to respond to the problem of ministerial involvement in procurement? Let's not get into which types of pressure we're talking about. You've given a range of different possibilities, but ministerial pressure or ministerial involvement in procurement itself provoked some guidance, didn't it?
Yes, and the answer is partly. So, partly to address if you read that as a document that I think was published in July 22, I think I drafted it in April and later in 21. Partly,
you drafted it?
Yes, with Chris Hall. So, partly, who you'll talk to later in the week, my lady. So, there are conflicts of interest tightening of wording in there. It's not for me to write or contribute to a ministerial code. That is not what the civil servant's allowed to do. But I thought that guidance would nonetheless be helpful to be clear on conflicts of interest. And what that established is the idea that as soon as the minister and the gentleman before me touched on this, as soon as the minister meets or has contact with a supplier who is interested in a procurement, they should declare a conflict of interest or not, but there should be a document done there and then. So that bit of it was triggered by the pandemic. Lord Maud, a few years before, I forget exactly when, had issued some very good guidance on how ministers could be involved, but his guidance was limited to the procurement process itself. What it missed was the pre-procurement, which is exactly the subject that the inquiry is rightly interested in, and also it didn't cover contract management, which you may be interested in. But so I was trying to tighten it up and cover that first and third block, if you like, out of the three around the centre that Lord Maud had already done a few years
Mr.
before.
Rhys-Williams, I'm going to have to do my best to tighten up the question and answer because we have a limited amount of time. You've got lots of very interesting things to say, but we're going to have to stick to the topics that I'm asking you about, if that's all right. I just want to know, were you also responsible for drafting the contract award notices guidance that came out at around the same time?
No.
You weren't? All right. Emergency procurement is something that seldom happens, isn't it?
Yes.
Yeah. Would you accept that even experienced procurement staff do not have much experience in emergency procurement?
Yes, by nature, it doesn't happen very often.
Yeah, and there wasn't pre-existing guidance available to assist those individuals?
Correct. That's why we put out the PPN 120.
Nor playbooks?
Playbooks are something slightly different. Playbooks are more how do we work with a particular different segment of our industrial base.
They're more focused in their remit?
They're not so much about procurement regulation as best practice, both from our side, the government side, the public sector side, and from the supplier side. They were co-developed with industry on a sector-by-sector basis in 4 sectors, one after the other, where government had persistently run into problems or industry had run into problems.
Would it have been helpful or desirable for there to have been a playbook, particularly for those, likely almost everyone, unfamiliar with the workings of Regulation 32, emergency procurement?
Yes, but it might have become shelfware. I think the PPN that was put out 120, which was the one that covered the use of Reg 32, I think was very, very thorough and went to everybody, and they would have read it because it was there on the desk at the right time.
All right. I'm moving on to transparency. We've touched on it already. You've made clear your views on it and the importance that you ascribe to it, not just even in an emergency, but especially in an emergency. You're, of course, aware of both High Court challenges. You've referred to one of them, the PestFix one, where there was a finding. In relation to that, there was a finding that the high priority lane was contrary to equal treatment principles, but there was also a High Court challenge that considered the late publication of contract award notices, of which I'm sure you're aware.
Yep.
Yeah. You agree that the late publication of contract award notices undermines transparency, doesn't it?
Yes, and I think in my statement I say it's one of my deepest regrets because it allowed, concerns to multiply, and it is a matter of huge regret that we just weren't able to get those publications done. And you will have seen in my statement lots of emails to DHSE, encouraging them in stark terms to try to find the resource to publish faster.
In brief, it erodes public trust in the process.
Yes.
Yeah. And that was in relation to PPE, but there were also late publications of contract award notices for ventilators, weren't there?
Yeah, that we've covered that in my statement. That was a regrettable oversight. As soon as that was highlighted, we published the contracts. We'd already published all the CANs, so the award notices, but we hadn't published the redacted contracts, partly because the CTT, the complex transaction staff, who were working on that, to be honest, don't normally do actual procurement turning the engine themselves. They're there to advise governments, and it was just a slip up. And as soon as that we were alerted to that, they were published.
I was going to ask you for the reasons for it. You've said regrettable oversight. I think, in fairness to you, we should look at the table at page 45 of your evidence. It's inquiry document 000497031. It sets out, as I'm sure you're aware, you included it in your evidence, the rather, if I may say so, onerous or even counterintuitive or clunky nature of the contract award notice requirements. Would you agree with that description of what was required and when?
Yeah, it's overly complicated and allowed people to say, oh, well, I thought I had to do this, but in fact, so there's a distinction made, my lady, between central government departments and arm's length bodies. Well, was SSCL an arm's length body because it belonged to DH, or was it, anyway. And it's complicated, different dates for different scenarios, and over a period of time, colleagues published different PPNs, clearing this up, and it's now, and in the Procurement Act, it's crystal clear. Now, the confusions in here, to be honest, none of those readings of confusions would explain we were late under any reading of this. I'm not trying to hide that. We were very late to publish, regardless of which column or box you pick on here.
The regrettable oversight was in part down to old-fashioned IT and data management tools, wasn't it?
No, the lack of publishing of the ventilator contracts, I think, was just an oversight. The complexity you talk about in DH was absolutely a part of that, reading everyone's evidence, and my understanding at the time, because the PPE buy-sell weren't allowed, for obvious reasons, to join the MOD procurement system computer, because that would have generated all sorts of security concerns, and neither were they allowed to join the DH system. And the SSCL system, at that time, it's been updated since, just didn't have enough space for enough users. So they were completely separate, and that generated finding the data problems that are talked about by my colleagues and in my statement.
All right. You've emphasised more than once in your evidence to us today the importance of transparency. Why was it that the Cabinet Office withdrew the transparency guidance in June 2021?
It withdrew the one from 2019 and clarified it along the lines of the table that you just showed up.
Beg your pardon, you're quite right. It was November 2017 is what it withdrew.
It withdrew the one from 17 and replaced it with a clearer version and in 2021.
And you say that the Act brings much needed clarity as well.
So, under the old regime, yes. Under the old regime, you had to do contract award notices right at the start when you're thinking about an award, and at the end when you placed a contract, and then actually when the contract timed out at the end. Now there are multiple, from memory, a dozen different contract notes you have to lodge at different stages in your procurement. Not only does the Act now require machine-readable data, which is obviously much more transparent, anyone can look at that, but it's in standard format. Only one unique identifiers. The gentleman earlier talked about different spellings for the MOD. We've got rid of all of that. We now have a machine with basically a drop-down data. So there is only one University of Sheffield, there's only one MOD, there's only one version of a customer, because there were we're trying to clean up procurement data. But it also, having a series of notices, as they're called, allows anyone, my successor, to look through and say, hang on, there's 7 notices here, where's the 8th? And chase up. So it goes to a couple of the comments from this morning about how do you ensure that the new transparency agreement arrangements are being put in place, and that's what Parliament has allowed us to do.
From this
it is
morning,
much better.
Again, is a reference to the evidence of Professor Sanchez-Graels, yes?
But I think also, forgive me,
Mr. Bruce?
Mr. Bruce touched on the same matter.
So, did you hear Professor Sanchez-Graels' reflections on the problem of enforcement within the new Act?
Yes, and that my comments just now sort of go to that. We weren't given by Parliament enforcement powers, but nonetheless, that stepped series of notices will be easy to detect if there's one missing, or if one has not been submitted that should have been, which is the mechanism I had to adopt halfway through the pandemic to work out who had not submitted the appropriate transparency requirements. So this will be much tighter in the new under the new regime.
Well, detection is one thing, enforcement is another. You'd agree with the professor that there is a problem in that the enforcement mechanisms are inadequate within the Act.
Well, I would say an alternative approach to that would be the NEO asking my successor every now and then to give them a list of which notice series haven't been completed, and I think that would achieve much of what I don't speak for the professor, but well, that would drive adherence pretty quickly.
All right, I don't think we're going to discuss now the relative merits of the two routes, but let's move on to the call to arms, which is a matter that you deal with relatively extensively in your written evidence. You were involved in the procurement of ventilators, as you've told us. there was a public call to arms for the supply of ventilators, wasn't there?
Sort of, but not in the same way as for PPE.
Not in the same way, but whatever it was, it resulted in a number of offers of support from businesses in relation to PPE as well, didn't it?
Yes, because by that time I think the public had woken up to the idea that we were in a problem situation, to put it mildly.
You wanted to avoid a call to arms in relation to PPE of overwhelming the system, didn't you?
I was nervous about that. We got some 5,000 responses to the relatively limited call for ventilators, and I was concerned, and that nearly broke the back of the team processing them, and I was concerned with PPE, which is a much more commodity item, that has indeed turned out to be the case. We would be drowned in offers which we would then need to go through, but which regrettably would probably turn out not to be worth pursuing.
Now, there was eventually a call to arms in relation to PPE, but even before that, the Cabinet Office and DHSC were receiving high volumes of offers, weren't they,
Yes,
before the call to arms?
it accelerated.
It made it worse
It accelerated, yes.
as a result of the call to arms.
I believe so, but I could get you that data, but I...
Well, let's have a look at can we display INQ 000497 031, please? And this is in your evidence. Many new suppliers responding to the pandemic emergency worked extremely hard to create successful products in a short time frame. This led to the success of the ventilator challenge. A very large number of offers for PPE, however, led to extreme stress on the procurement system. And then here are the numbers, which I didn't expect you to recall, hence putting it up on the screen now. Approximately 25,000 offers were received from 15,000 suppliers in a period of only around 15 weeks. So the system was under enormous strain as it was.
Yes, the point I was trying to make earlier is I think the initial series of offers for PPE that came in after the ventilator call to arms, much more limited, accelerated when there was a PPE call to arms. So that's the point I was trying to make.
Now, you've expressed your views on the risks of thank you very much for that display, on the risks of a PPE call to arms, but you were invited to express your view at the time, weren't you?
Yes.
On that. And you did so, didn't you? You said that your office replied on the 23rd of March to state that you would support a call to arms for PPE, but only if there was a dedicated mailbox for it and a PMO team to triage the offers coming through effectively. And you made a series of recommendations in relation to it, didn't you? Do you recall?
Yes, not the individual ones, but yes, absolutely. I think it's fair to say at that time a decision had been taken by ministers to have a call to arms, and I was saying, well, OK, if that's what you want to do, but please can we have this ready to go before you do it?
We'll bring it up on the screen if necessary, but it may not be so. Your recommendations, perhaps on the basis that it was a fait accompli by then, included reducing the amount of human interaction by using a web form. Yes? Avoiding a situation where emails were going all over the place, and requesting details of product specification, volumes and delivery dates. And then you said this: if it's anything like the response to ventilators, you will be inundated with offers, possibly even more, given some of the items are less technical than others. And this is your commodity point, isn't it?
Correct.
Yeah. So picking up on the first point first, why was the advice that you gave to reduce the amount of human interaction?
So with ventilators, what we were initially trying to get was a ventilator, a unit. Most of the 5,000 things that came back, offers that came back in, my lady, were for bits, for components, which useful but not that useful. That's not an option with PPE. It's either, it is what it is. The mask is a mask. And so it was obvious that we would need to be much more specific about the items that someone was offering, and that's why the web form ended up with the question set that it did.
Wasn't it the case that you were anxious that those individuals responsible for triaging offers should be protected from the deluge by a web form, by the requirement that a number of specifications were offered by whoever it was that was making the offer at the outset, effectively removing the human burden on that process of triage?
Well, reducing it. I don't think you were ever likely to remove it because, as you heard this morning, there are the word gowns. There are lots and lots of different flavours of gown, but at least it would, do the first cut of what is being offered.
To your knowledge, was any of the advice in your Joint Chief of Staff note followed in that call to arms?
Well, we did end up with a web form. It went through a number of iterations.
But the call to arms proceeded in any event. You've indicated a moment ago that it was a fait accompli by the time you were giving advice. But a few days later, the call to arms was made, wasn't it?
It was going to happen, then it was postponed, then it was postponed, then it happened. But there was, if you remember the daily briefings, there was plenty of talk about the country is short of PPE. So everybody knew that this was...
Matt Hancock made the announcement that contained the call to arms, didn't he?
Yes.
Yeah. And what was the effect of it? Were your fears well-founded? What was the effect of those that were already experiencing a significant amount of pressure?
Well, as the data that you put up shows, the call to arms worked in the sense that we got lots and lots of offers, and we had to race to find more and more people to staff the PPE cell in order to deal with those offers, and substantial backlogs built up because we were not able to find enough people fast enough to be winning against the rate of inflow of new offers.
It consumed your team, didn't it?
Well, I think we ended at 500 and change people in the team. So this is people from all over government that we were drafting in to do this work. So if you meant by my team, the complex transactions team, yes, but there was 35 of them. This was multiples of that.
What you tell us in your evidence is that over the following days, it became clear that the offers being referred had the capacity to overwhelm my office.
That's a slightly different point. So initially, I think my office email was used before we had a web form. Then we built a web form, then we built a better web form, and that then meant that the offers didn't go direct to the, by then, probably half a dozen people in my office who were triaging. But that was right at that was in the early couple of days of the PPE offer period.
Can we display now, please, to get a sense of how it was experienced by those responsible for the day-to-day? So Chris Hall was an example, Max Kenduff another example. Could we have INQ 000534626, please? Do you see this email entitled, "I dream about this stuff"?
All of us had, I think there might have been allusion to the fact that none of us were getting any sleep. Yes, I remember that.
And then if we scroll down a little bit, we can see Chris Hall writing, "We have designed the least efficient process possible." Note the date, 13th of April. Secondly, the lag in the process and shipping is killing our demand signal. What do you understand by that? He sets it out a little bit underneath there.
So a couple of things about that email. What's missing from this photocopy of it? So Chris blind copied me into that. So this was a discussion between him and Max. So as you heard today, the process that was put in place for the people was very linear. One team, then another team, then another team, then another team. Now that is very good for stopping corruption because you would have to engage, an individual person in all of those linear steps in order to get a corrupt response. I'm sure we'll come back to that. But there are lots and lots of handoffs in that. So that's what I understand Chris is meaning by least efficient process. And it was shortly after this email that Chris and the team, Andy Woods and others, started thinking about the rapid reaction teams that you touched on earlier, which are much more flexible. But if you're going to have a rapid reaction team, which they decided to organise by category, i.e. one team for gowns, one team for gloves, one team for masks, whatever, you need people in those teams who actually understand the product much more than you do if you've got a pool of people that you can access in the linear structure that we started with. So that's what I understand. And the lag, we were being very slow, weeks in some cases. Not across the detail, but I'm sure Chris or Max or Andy will be able to give you the detail. We were taking weeks in some cases to process even the good offers.
And that's crucial, isn't it? Because in a volatile market, in a competitive market, speed of processing of offers is absolutely crucial. That's right, isn't it?
Absolutely.
Yeah. Which means that any offer that is processed more quickly, by dint of that alone, will have a better prospect of succeeding in securing a contract. That's the finding of the High Court.
Yes, perhaps I could put a little nuance on that. I think the High Court was talking about the early stage of introducing it to the technical team. This is an unusual situation. Most procurements, my lady, you put out a bid, you say what you want, and there are dates and then an order. With this, we were getting constant offers, and DHSC was wanting to make constant offers. So there is an issue with, irrespective of speed, and we've done some analysis recently, which you'll probably want to talk to Chris Hall about, you need the offer to land at the same time as the requirement. So suppose that a gowns offer had gone fast through the system. If it turned up the day before there was a gowns requirement, it wouldn't necessarily have resulted in an order. On the other hand, one that turned up slower, but after the requirement had been flagged, might go, aha.
Well,
So it's not.
Let's deal with that point.
It's not like a normal system where there's like a racetrack. It's the first across the finishing line. There were being contracts placed repetitively multiple contracts every day. I think for most categories.
There was internal guidance that recommended or that required the rejection of offers that were 2 weeks old or more, weren't there? Wasn't there?
I think that was something within the technical approval stage, yes.
Yes. So you're not suggesting that an offerer might benefit from delay in the processing of his or her offer, are you?
I'm saying it's much more random. It's not a question of everyone starting at the same time, who gets to the finishing line first gets the order. That wasn't how it was. I wasn't running the team, I wasn't in the team, but that was my understanding at the time and remains my understanding.
Well,
there were multiple offers coming in on different days and multiple orders being placed on different days. And so you needed your offer for whatever it was to match the demand for whatever it was on the day that happened, and they might be weeks apart. I think there's a lot of, I think Chris has done some analysis recently, which I think the inquiry's got. There's a huge variation in the amount of time that offers took to got through the machine. So it's not as deterministic as I think. I sympathise with what you're saying, and in a normal race event that would be true, but I think it's a little bit more nuanced.
You're not aware of any of those that chased for feedback on offers, asking that their offer should be slowed down, are you?
So, no, but neither am I aware of them, which is not to say there weren't any. The inquiry has a lot more information than I had at the time and have now. But that's why I tried to draw the distinction earlier between asking for, have you assessed this offer, is annoying but legitimate, whereas place an order with that person or speed that up is not legitimate unless it's a very attractive offer. So there were days, I'm sorry for the lengthy answer, but there were days when, as I understand it, Emily Lawson got a demand signal from the NHS that gowns are very urgent today, we're about to run out, or gloves are very urgent today, in which case that would be a good reason for accelerating pulling things through the system.
We'll come on to modelling in due course, but the reality is that for a long period, so far as PPE was concerned, the practice was to acquire as much as possible, as quickly as possible, wasn't it?
Yes, in which case the time that the offer got there is not so relevant either.
Well, that's not quite right, is it, Mr. Rhys-Williams? Because those that made their way to the decision sooner than others, given that there is guidance that says 2 weeks or more, the offer has expired, you've got to get to the decision-making process within 2 weeks in order to be in contention for a contract.
I deferred to others on this, but I think that 2 weeks related just to the technical assessment phase.
All right. Well, we'll wait. We're here on Thursday from Mr. Hall and from Mr. Kenduff. We can pick up these points with them. But looking back, the call to arms was a mistake, wasn't it? It was counterproductive.
I can understand why politicians felt it needed to happen, but it had some very, very serious ripple, but more than ripple. It caused huge problems, and a lot of the problems that the inquiry is rightly looking into, I think, flow as much from that as they did from our lack of stock to start with.
Well, that's a very, if I may say so, diplomatic, if telling response. You can understand why politicians felt it had to happen. It was an announcement that was counterproductive in terms of the challenges of procurement at the time. That's fair, isn't it?
Yes, the yield from the offers generated through a call to arms rather than getting the industry into a room, which is what we did with ventilators, I suspect was marginal.
It's an example of ministerial pressure or ministerial interference proving unhelpful, isn't it?
Yes, I wouldn't describe it as pressure. It was a decision that ministers took to engage the country.
Against your advice?
Yeah, yes.
It's even an example of ministerial deference as explained to us this morning by Professor Sanchez-Graels, isn't it?
I would say it was slightly different. I mean, there was no way on earth I could have stopped the Secretary of State for Health, getting on TV to say what he said. So, ministers are, enabled to take those sorts of decisions.
No, the only practical way of doing so would be to be even more forthright in your advice or your caution. That would be all you could have done.
Yes, the notes are pretty forthright, and I suspect he was getting similar, I don't know, there's similar advice from within DHSC, so he wasn't my minister. So, and again, the government doesn't work like.
I want to pick up with you the theme of different forms of pressure. We've looked at ministerial pressure. It's one of the forms that I want to ask you about. Procurement teams, particularly at the start of the pandemic, were under enormous pressure to make progress and secure PPE, yes?
Yes.
Now, I'm going to suggest to you that pressure can be thought of in the following 4 categories. Frontline staff pressures, i.e. the obvious pressure that arises from the vital need to supply those on the front line with urgently needed PPE, yes? Ministerial pressure, and we've touched on that. Political pressure, which is slightly distinct. And then pressure from the media. Now, clearly, first and foremost is the frontline staff pressure. I'm not going to develop that with you. I see you nodding. You'd accept that is first and foremost.
Everybody was watching the videos from Newsnight and knew exactly what the problems were and how ghastly it was.
You have referred several times in your statement to ministerial pressure. Examples are at paragraphs 38, 103, and so on. You yourself paint a picture of ministers and the media generating real pressure for those procuring PPE to demonstrate progress. That was the day-to-day experience, wasn't it?
Yes, but but I don't believe that was on specific orders. It was, where is the PPE?
Did it result in being a distraction from the important task of actually assessing offers and negotiating sensible contract terms?
I don't think the media was a distraction. Civil servants aren't allowed to talk to the media, so it was a constant reminder of the state of the country and the state in hospitals, and that people were dying. So that generated a lot of pressure. But ministerial pressure translated into chasing, and I wasn't in the team, so I defer to my colleagues, but my understanding at the time and now was that was, have you processed this offer rather than order from this person? And so I think that you need to distinguish between noise and pressure, perhaps.
No, well, you made that point earlier, but let's take that example. You have an offer that comes in, say, through the high priority lane. It's followed up by a request for feedback. There are also many offers that come in that are outside the high priority lane, yes?
Yes.
They, of course, are not followed up with any request for feedback. There is no referrer for those offers, unlike in the HPL.
I'm not sure that's true, because large offers that came through on the non-HPL would rapidly have become known to people, and so would have generated, where have we got to on that one? That looked like a good one. But it was perhaps from a different set of people. I don't know. Again, I defer to my colleagues on that.
But even if, as you say, the request for feedback was not to the point of, strike a contract here, but rather, what is the state of play in relation to this offer? That request for prioritisation could quite easily have proved a distraction to the task of assessing offers on the ground against all the data that was available. I mean, you must agree,
yes,
surely, that it may have had that effect.
It was a distraction, and that's why I think the idea behind the HPL, I wasn't involved in setting it up, but I think the idea was to have a single point manned by rather more senior people than were generally found in the opportunities teams, to be able to pull all that in one place. If the inquiry accepts that the chasing was inevitable, the alternative was to distribute the referred offers across the 8 opportunities teams, in which case the questions would still have arisen, but they would have been harder to respond to, and probably, because there were more junior people in the other opportunities teams, I suspect, that the effect that you allude to of does this generate action would have been more of a risk than the way that we did end up with it. But again, I defer to my colleagues on that.
All right. I said that I was making a distinction between ministerial and political pressure. Could we now please display INQ 088672, and just have a look at paragraph 3 of this. This is, it's a cabinet, minutes of a cabinet meeting, 4th of May 2020. Paragraph 3, DHSE to produce by close on Tuesday the 5th of May a plan which sets out proposition for the definition of the PPE test, a clear and credible set of steps that will be taken to meet the PPE test, and a forecast of when the PPE test will be met, including an assessment of whether the test can be met by the end of the week. This plan should be consistent with the data picture set out in the CCS dashboard. Was that sort of test, and once it had been set, the requirement to meet that test helpful in your view?
So I wasn't at that meeting, and I don't think I would have seen that minute until it showed up in the evidence packs. I believe that the test they're talking about there is the, have we got, pardon me, have we got 4 months, sorry, my lady. have we got 4 months of stock of everything, which was a key test, I believe, that the Prime Minister had set before releasing lockdown. I think I should also clarify, CCS in that sense of the word there does not mean Crown Commercial Service, but rather means Civil Contingency Secretariat.
All right, understood. Okay, so that's your answer in relation to that document?
Yes.
Yeah. So far as media pressure was concerned, you were aware of significant media scrutiny. In fact, you referred to it earlier in relation to the GIAA reports and what you described as negative media attention. That's paragraph 38 of your statement. Yeah?
Yes, the media, there were a lot of stories in the media about PPE buying.
Would you say that concern about public perceptions regarding the progress in buying PPE consumed a lot of government time and energy during the pandemic?
Well, government, well, yes, because media does consume a lot of government time.
But by those who were responsible for procuring? Were they placed on?
Could you let me know which document you're looking at?
No, I've just asked you a question. You refer at paragraph 38 of your HPL statement. Which I don't have an inquiry document number.
So I've got it here.
You've got it, great.
38 is talking about the rapid response teams.
No, I'm talking about media scrutiny. Or paragraph 88.
Aha, sorry.
Inquiry document 000531549.
Oh, I've got 536362.
If we go to start at 38 and then move on to 88.
So 88 talks about an overwhelming number of offers, but that's in my HPL statement.
Yeah, that's what
I'm so
I've got.
sorry.
Oh, sorry. 536362.
Yes. Which paragraph? Sorry.
Unless they've changed, it's 38 and 88.
The one I've got 38.
Para 38.
Oh, page 38. Sorry.
It's now 39.
So your colleagues have put up page 39.
No, para 39, page 15. Forgive me.
Ah.
A hot political issue.
Possibly that's political with a small p. There was a discussion at the time, so I'm just reading this, but my memory of that meeting is there was a discussion at the time as to whether PPE procurement should move from DHSC as being the lead department to Department for International Trade. And the Cabinet Secretary, who was Mark Slibble at the time, called a meeting to discuss that. Well, there were several meetings to discuss that.
And
I mean, it was a hot political issue with a capital P, meaning ministers as well. But what I intended to say here was, there was some debate internally as to how who should lead on this.
And you say at 89, I don't know if you've got paragraph 89 there. in such a situation, it was perhaps inevitable that individuals who had PPE and were wanting to sell it to the UK would do what they could to bring that to the attention of those with power in the administration, ministers, MPs, and senior civil servants, including using any links or contact details that their company might have. And that really is the genesis of the HPL, the high priority lane, isn't it?
No. So, yes, any supplier, whether for good reason or bad, will try to get to the highest decision maker, or as they perceive it, point that they can in order to say, I've got this stuff, it's really good, you should buy it. And there were lots of very well-intentioned people who did just that, and quite a lot of bogus offers in that way. The HPL arose from what happened next, which was once ministers or other offices or other officials' offices had referred those, often with a just over to you type of referral note. Colleagues can talk about those, and you've, I think, got examples. The HPL was in response to then the chasing calls to what has happened to the thing we sent you 3 days ago. Have you?
That's right. Because they,
It wasn't the action of the suppliers per se that generated the HPL. It was the chasing subsequent.
it was the referrers, that, to put it bluntly, because the referrers were relatively demanding, the high priority lane was set up.
Yes.
Yeah. And we see that from inquiry documents 000498 337, or at least we see an indication of the origins of the high priority lane. Email from Mr. Wood. Does it go over onto a second page? Yeah, if you could scroll down, please. That's it. Another action I took was to advise Lord Agnew if we could fast-track ministerial seniors' emails regarding offers of help that they were sending through. We've developed a public pro forma, very simple, that automatically populates our database. We may change that by providing a field that alerts us to a ministerial seniors link, but we need to do this carefully so as to avoid ministers' inbox being clogged up with scammers claiming association. In the meantime, and for Lord Agnew, please send hot leads to myself. Is that consistent with what you understand to be the origin or the genesis of the high priority lane?
Yes, I can't see the date on this, but I suspect that was at the very start.
Well, if we scroll up
public
again,
pro
we
forma,
might
I think they're talking about is the web form.
25th of March.
Yeah, so right at the start. The problem that this generated, or of offers coming directly into someone's office, is that they were bypassing filling out the pro forma, and therefore there was different. We had to get hold of that information or somehow populate that ourselves in order to know exactly what they were talking about. So I think that's what he means by the pro forma there. But Andy will be able to. I don't think I saw this at the time.
Now, I think I'm right in saying that in your evidence, the only concern you express about the HPL is in relation to its name. Is that right? Is that fair?
No. The problem we had anyway is once you have, as I said earlier, a China team, a Make team, several opportunities team, is that we are already in dangerous territory from a point of view of fairness, because inevitably there are different routes, and that is not what you should strive for. And that flows directly, hence my comments about the number of offers and the call to arms. One flowed from another. We just couldn't put all of those offers through a single channel. So we were already in a, how do we handle this? We are in, tricky territory from a fairness and consistency point of view.
But that's a slightly different point to the one I was asking about. What were your other concerns about the high priority lane? Its name was one of them, wasn't it?
Well, yes, that it's another different route.
you were concerned that the name would suggest that the buying process favoured a particular subset of sellers.
Yes, yes. I don't have my list in front of me. There's a whole list of things I was worried about, principally that it would give the wrong impression to everybody. Now, calling it a high priority, so important to recognise, I think, the word lane was only introduced by the NEO when they did their report some months later. At the time, colleagues will know better and can talk to my lady more about this, it was called the VIP or whatever, or a high priority. Now that is helpful in, frankly, calming down an irate multinational chief executive who's written to their MP or whoever. It is very unhelpful in the context that we're discussing it here, for exactly the reason that we're discussing it here.
You were also concerned that it was a very important person rather than product lane, weren't you? The focus was on an individual person rather than the product being offered.
Oh, that was my concern, that would be the implication of the word VIP.
That was certainly the appearance.
Yes, and I think, I'm afraid I was right. It would have been better, had we been able to do it, to have a team who just handled the handling aspect of these chasing, completely separate from anyone involved in procurement, not staffed by any staff with a procurement qualification. That, I think, would have shown a fire break between chasing and progressing. But at the time, we didn't have the people and things moved too fast.
You were right that it would give rise to the appearance of preferential treatment to certain individuals. We'll move on tomorrow to whether there was any actual preferential treatment as a result of the VIP or HPL, the VIP lane or the high priority lane. But before we, if we could just finish on one point, I note the time. In relation to the concerns you had about the name, just the name, did you act upon those concerns?
Yes, so I got a call about this around, I think, shortly after it was set up, and as I described it to other colleagues, I think my first reaction was Anglo-Saxon in expression because of the risks that we talked about, and I asked if we could change the name, and I was told, no, this is already set up and running, it's been communicated out to other offices, it is what it is. So at the time I was running the ventilator program full pelt, but it was very clear, that ship had sailed.
Well, you had a 2-minute conversation with Dame Emily Lawson about it, didn't you?
No, I can't remember. I didn't note who I was talking to, and I remember it was a discussion as I walked from my kitchen to my office, and it was we've been asked to set up a lane called a team called the High Priority Team, or the VIP team. I can't remember the exact.
You say at 47 of the same statement, your 14th of January statement, what I've described as the HPL statement, 000536362. I do remember asking if we could do something about the name. However, I was told that it was too late, as it was up and running and widely communicated. If it had been called an inquiry response handling team or similar, I think it would have avoided a lot of the negative implications and consequent interest which has arisen since. I cannot recollect whether I expressed my surprise verbally or in a text or email, but since I cannot find an email relating to this at the time, there it is up on the screen. I note that in January 2021, I made a similar point by email. That was the extent of what you attempted to do about its name, wasn't it?
Yep.
And you had no objective basis, did you, for concluding that offers that came in via the HPL, that referred into the HPL, were better or worse than offers received by other ways? You had no objective basis for concluding that, did you?
I think the smaller, so the non-priority lane, the other lane, again, colleagues who are actually working those cases would know this much, much better than I do, but my impression was that a lot of those were for very small amounts. Some people were offering to hand make scrubs, which is brilliant and helpful, but was never going to do it. So it's much more likely, I thought at the time, that corporates would have asked someone in their office to find the email of the minister or the officer. I mean, these are available on gov.uk. So, but that was the limit of how I thought about it.
All right, my lady, I note the time. Would that be a convenient moment to
Certainly.
adjourn?
You've obviously been warned. I do try to avoid having witnesses come back overnight, but I'm afraid it proved impossible. I did ask some time ago whether we could get through in one day, but I hope you don't mind coming back.
No problem. These are important matters.
Thank you very much indeed. I shall return for 10 o'clock tomorrow.
All rise.